In my last presentation, I have discussed various sections of the laws, intellectual property laws, under which you can challenge the order or the decisions of the respective intellectual property offices in India. Today, I will discuss in this presentation about the procedural aspects of appeal proceedings before the Intellectual Property Division of the Delhi High Court. To understand the procedural aspects, we must identify which are the various forms we need to use while filing the appeal against the order or decision of the Intellectual Property Office in India. If you wish to challenge the order of the Trademark Office, then you need to use the form number 2 while filing the appeal. If you wish to challenge the copyright registrar office orders, then you need to use form number 7. So the table discloses the various forms required to be used for filing the appeal against the orders of the respective intellectual property office in India. The second most important point to consider while filing the appeal is under which section of the relevant intellectual property law you are going to file the appeal against the impugned order of the intellectual property office. In our separate video, we have explained the various sections briefly and what is being covered under these sections. You can refer to this video and understand more about the various sections which empowers you to file an appeal against the impugned orders of the respective intellectual property offices. And the third most important point to consider is the limitation period. If you look at the table, except under the IT Act 2000, you will have 3 months timeline from the date of receipt of the impugned order, within which you can approach the IPD of Delhi High Court and file the appeal proceedings against the impugned order. So, what will happen if you miss this 3 months deadline period? Can you still file the appeal even after the expiry of the 3 months? The answer is yes, but it depends upon the facts of the case. For example, if you were diligent and there are valid reasons for your delay, then the High Court has power to condone the delay and still entertain the appeal against the impugned order. However, you must be very clear if you do not have any valid reason, you cannot consider this 3 months time period as a casual time period and file your appeal against the impugned orders even after expiry of the 3 months. Finally, in the last column of this table, you will find information about the filing fee which needs to be paid at the time of filing the appeal against the impugned orders. So, having understood about the various forms, what are the various sections under which you can file the appeal against the impugned order, the fee requirement and the limitation period requirement, what will be the content of your appeal petition? In your appeal petition, the form must be there as indicated in the last slide. The fees must have been paid to the High Court. Then the memorandum of parties, it must include each and every respondent which were also the party before the intellectual property office. For example, if you are challenging the patent opposition order issued by the Controller General of Patents, then you must include the patent office in your respondent and the applicant or the patent owner of that specific patent which you have challenged under the patent opposition proceedings before the IPO. After the memorandum of parties, you give a brief synopsis in the appeal petition, the list of dates, memorandum of appeal would be there, and the important section in your appeal is the grounds of your challenge in the appeal petition. For example, you did not get any opportunity of personal hearing before the intellectual property office. So that violates the principle of natural justice. So that ground should be covered in your appeal petition. In another example, let's say the patent office rejected your patent on a ground which was never shared with you earlier in any of the first examination report or any second examination report. So in that case, you have a ground to challenge that impugned order because you never got an opportunity to put forward your case before the controller of the patents on the new objections raised by the Controller General of the Patents. So in this way, you have to clearly and explicitly include all the various grounds based on which you are going to challenge the impugned order or the decision of the Intellectual Property Office in India. Rest of the documents includes obviously the impugned order which you intend to challenge before the IPD of the High Court, the affidavit of the appellant, and also you must disclose each and every detail about the prior litigation on the similar subject matter before the High Court. Normally, all the IPO documents would be part and parcel of your appeal document. But in case you require to rely upon additional documents, you must seek the permission from the court to file the additional documents. So once you file all the relevant documents with the registry of the Delhi High Court and you did not get any objection, your appeal will be registered as per the nomenclature defined in the Intellectual Property Division rules of the Delhi High Court. So after registration of your appeal, the matter will be listed before the single bench of the IPD of the Delhi High Court. And if you are able to satisfy to the single bench, then the Honorable Delhi High Court will issue a notice to the respondents. Normally, the process of filing reply and then you are filing a rejoinder to the reply is not followed in the appeal procedure. However, it is at the discretion of the Honorable Court to seek a reply from the respondents, and then you can later on file the rejoinder to the reply of the respondents. In addition, no evidence will be entertained by the Honorable Court in the appeal proceedings. However, a witness which has deposited before the IPO can also be called by the Honorable Court to appear before the IPD of the Delhi High Court. If required, a written synopsis plus judgments will be given to the Honorable Court, and after the final arguments, the judgment would be delivered by the single bench of the IPD of Delhi High Court. As an appellant, you will get different kinds of relief from the IPD of the Delhi High Court. First type of relief could be in which the Honorable Court may set aside the impugned order issued by the Intellectual Property Office. Second type of relief could be wherein the Honorable Court may direct the IPO to reconsider the impugned order and reissue the order after consideration of the merit points raised by the appellant during the appeal proceedings. The third kind of relief could be some directions may be given to the IPO to rehear the appellant or to provide one more opportunity to the appellant to put forward its views before the IPO. So I hope that this brief presentation would have helped you to understand how you can challenge the order or decision of the Intellectual Property Office before the Intellectual Property Division of the Delhi High Court. And thank you very much for going through this video, and stay tuned to this channel to understand more about IPR practice in India. Till then, thank you. Jai Hind.